we need to talk about the latest developments in the ongoing battle over the ATF's pistol brace rule. Right now, there is a nationwide vacatur in place, effectively blocking the enforcement of the rule across the country. Several preliminary injunctions have also been issued, protecting organizations, their members, companies, and customers from the rule's impact. But the situation is quickly evolving. While the Trump Department of Justice has allowed this issue to move forward toward oral arguments, that entire process may be halted altogether, because Congress is now stepping in to take legislative action on the issue of short-barreled rifles, or SBRs. Here's where things stand. Under the Biden administration, the ATF pushed a rule attempting to classify brace-equipped pistols as SBRs, placing them under the National Firearms Act. However, that rule has been challenged in multiple courts, leading to several legal victories for gun rights advocates. At the same time, with a new administration now in office and President Trump issuing an executive order focused on protecting Second Amendment rights, everyone was watching closely to see what direction the DOJ would take. The Trump administration recently informed the Fifth Circuit Court of Appeals that it wanted to pause the pending review of this case to reassess how it plans to proceed. The court granted a temporary stay, which was scheduled to automatically dissolve on April 14th. That date has since passed, and the administration has yet to submit any updated briefs or legal arguments, nor has it provided any further guidance in the case. As a result, the Fifth Circuit has now scheduled oral arguments in the case for August 4th. That decision suggests the court may have received some indication from the administration that it still intends to continue with the case, for now. However, that upcoming hearing could quickly become irrelevant. Congress has now entered the picture by including the SHORT Act in a new legislative package. If this bill passes both the Senate and the House and is signed into law by President Trump, it would effectively nullify the Biden-era pistol brace rule. In that scenario, not only would the rule become unenforceable, but ongoing lawsuits, like the Mock case and others in different circuit courts, would likely be dismissed as moot. It's important to remember that in the Mock case specifically, the ATF has already suffered several setbacks. Multiple courts issued injunctions against the rule, and most notably, Judge O'Connor recently issued a final ruling that struck the rule down on its merits. His decision imposed a nationwide vacatur. In his ruling, Judge O'Connor made it clear the ATF's final rule was legislative in nature and was not a logical outgrowth of the proposed rule. He concluded that it was unlawful and must be set aside, or at the very least remanded for further review and correction. Judge O'Connor's decision was a major turning point. It wasn't just another temporary injunction. It was a final ruling on the merits that struck down the ATF's pistol brace rule nationwide. In essence, that decision invalidated the rule, at least for the time being. In response, the Biden administration and the ATF immediately filed an appeal with the Fifth Circuit Court of Appeals. All necessary briefs were submitted during that time, laying out the administration's legal arguments in support of the rule. Everything was in place for the case to proceed toward oral arguments. However, the situation shifted once the new administration took office. Now, under President Trump, the Department of Justice requested a temporary pause, an abeyance, to delay oral arguments. The reasoning behind that request was to give the administration time to review the case and possibly reassess its position, which wouldn't be surprising given how the Trump DOJ has already changed direction in other firearms-related cases. For example, we've seen the Trump administration change its stance in the Peterson suppressor case, where policy was reversed. The DOJ also filed an amicus brief challenging Illinois' magazine ban, and they've made several additional filings to the Supreme Court on Second Amendment-related issues. These moves signal a broader shift in legal strategy under the Trump administration. But when it comes to the pistol brace rule, we haven't seen any definitive action yet. Despite requesting a pause, the DOJ has not submitted any updated briefs or statements indicating a shift in position. Because of this inaction, the Fifth Circuit went ahead and scheduled oral arguments for the week of August 4th. This decision suggests that the court may believe the administration still plans to defend the rule, or at the very least has not communicated any intent to withdraw or change its argument. So, unless the Trump administration explicitly clarifies its stance, the court appears ready to move forward with the case. That said, it's unlikely the Trump DOJ actually intends to defend the pistol brace rule. But until we see a formal update, that's the posture the case is in. What's also worth noting is that the Attorney General's office has publicly acknowledged that the administration has reversed course in other firearms-related lawsuits, like the Peterson case and the Illinois magazine ban, but so far, nothing has changed on the issue of pistol braces. There's a possibility that the Trump administration is waiting to see how things play out in Congress before taking a definitive legal step. That's where the SHORT Act comes in. Recently, there was a successful push to include the SHORT Act in H.R. 1, a major legislative package. If this bill passes the House and Senate and is signed into law by President Trump, it would render the entire pistol brace rule irrelevant. That's because the rule is built on the premise that brace-equipped pistols should be treated as short-barreled rifles under the National Firearms Act. If the SHORT Act removes SBRs from the NFA's jurisdiction, then the ATF's entire legal foundation for regulating brace pistols collapses. The rule would no longer be enforceable. In that case, not only would the rule be invalid, but all ongoing lawsuits related to it, including the Mock case, would likely be dismissed as unnecessary. If you want to help bring an end to the pistol brace rule, one of the most effective actions you can take right now goes beyond just following this legal case. It involves direct engagement with your elected representatives. I strongly recommend reaching out to your U.S. senators and letting them know that you support two key pieces of legislation, the SHORT Act and the Hearing Protection Act. The SHORT Act seeks to eliminate the restrictions placed on short-barreled rifles under the National Firearms Act. The Hearing Protection Act does something similar but focuses on removing suppressors from NFA regulation. Both bills strike at the foundation of many of these overreaching regulations. You can contact your senators by calling 202-224-3121. When you call, make it clear that you support both of these acts and want to see them stay included in H.R. 1, the larger legislative package being pushed forward. Now here's something important to understand. The oral arguments that are currently scheduled by the Fifth Circuit do not affect the nationwide vacatur issued by Judge O'Connor. That ruling remains in effect unless either the Fifth Circuit overturns it after oral arguments, the Trump administration intervenes, or Congress passes legislation like the SHORT Act. Personally, I hope those oral arguments end up being irrelevant, because if the SHORT Act is passed and signed into law, it would eliminate the legal foundation for the pistol brace rule altogether. That would not only resolve the issue, but also make these ongoing lawsuits unnecessary. Regardless of what direction the administration ultimately takes, we're in a strong position going into the Fifth Circuit review. I believe the court is likely to rule that the brace rule is invalid under the Administrative Procedure Act, just as they did when they reviewed the earlier preliminary injunction. And again, I sincerely hope the Senate keeps both the Hearing Protection Act and the SHORT Act in H.R. 1, and uses this opportunity to significantly roll back the overreach of the NFA. If that happens, we may finally reach a point where SBRs and suppressors are no longer subjected to such outdated and burdensome regulations. So that's the current state of this legal battle, where we stand with the pistol brace rule, how it connects to the broader issue of SBR regulation, and what role Congress and the Trump administration may still play. I'll continue to keep you updated as new developments unfold. Thanks for watching. Be sure to like the video, leave a comment below, and subscribe to the channel for the latest updates on this case and others like it.